call it first.
Sure, I don't have the agenda up. Who's listed first?
Thomas Weiss.
Thomas Weiss, it is then. Right, we are on the record and welcome Mr. Weiss.
Good morning. I am Thomas Weiss, a resident of Montpelier, and I thank you for making time to listen to me this morning. I'm a civil engineer with many years' experience with environmental reviews, training, permitting, and Act 250. Based on my experience, I ask you to reject the following portions of the joint proposal: the Enhanced Natural Resources Board, the exemption for certain transportation projects, and the granting of presumptions to all state permits. Concerning the enhanced board, there's the joint proposal that would do away with the successful citizen-based district commissions and substitute in their places a centralized enhanced natural resources board. And I'm not telling you anything you don't know already. And the proponents claim that an enhanced board is intended to provide consistent application of criteria statewide, an accessible and fair process for Vermonters, and increased governance over the Act 250 enterprise. The regional...
Excuse me one moment. I just noticed that Representative Anthony is here, and I think we may end up taking your bill introduction after lunch, if that works for you. That doesn't work for you?
It doesn't. I already agreed to be at family court as a legislator observer at 1 o'clock.
Okay.
If you like, I can start over, and you can do that now. I'm trying to give you some flexibility.
No, I appreciate that. Thank you. I guess so. Thank you.
So I shall resume later.
We will go to okay. I'm not sure what that does to our next witness. Are you Renee?
I am Renee.
Okay. So, this is going to make probably, well, we'll see.
I can
Anthony.
come back after lunch.
Okay, great. Thank you. Representative Anthony, then, please join us.
Thank you very much. I'm sorry if my
That's okay.
other obligations have imposed
Yep, we have to.
undue burden.
Undue burden? Are you trying to be funny?
Yeah. Successfully.
That's what we do, undue burden.
I know you do.
How do you define that?
Thank you for joining us.
Thank you very much. I was invited to come and have spoken to many of you on H633. It's a relatively straightforward bill, which I believe has arrived, so to say, at its time. It basically lowers the elevation of specific and extra care in Act 250 from 2,500 feet to 1,500 feet. I note that at least one other proposal out there in the atmosphere also regards 1,500 feet as a worthy objective to exercise special care. I realize that this may impact some projects that someone might want to do. I'm particularly persuaded, however, when I drafted the bill by one of your existing criteria that goes back to the origin of Act 250, and that is the protection of headwaters. I think we know a great deal more and also have heightened respect for the mysteries of why the water comes out of rock at certain elevations than we used to. What we do know, however, doesn't necessarily allow us to permit development to occur between 1,500 and 2,500 feet. It's my feeling that caution is probably called for. And so I thought, with all the respect I have for the undue burden language in Act 250, that if people can essentially assure the district commissions, however that revision evolves, that they will not threaten headwaters, then go to it at 1,500 feet or above. But I just think that those are very special areas, they're scarce areas. It's unlikely if they are in any way adversely, if they're in any way adversely affect the headwaters of many of our rivers and streams, we will be unlikely to remedy that retrospectively. And consequently, I really feel that the extra caution is warranted. As you can see, I not only have lowered the elevation in my proposal to 1,500 feet, but explicitly added the inclusion of state, county, and municipal purposes in the course of jurisdictional review. I think that that's the practice. I think that that was the intent. Many of those activities are already, if you will, subject to permit. So that's not really an expansion, but I want to be explicit about it for any activity above 1,500 feet. And with that, I'll ask if you have any questions. I think I've hit at least on the purposes and my worries should development proceed without jurisdiction above 1,500 feet.
Do we have questions for Representative Anthony? All right, thank you.
Thank you. A little footnote, I think many towns have already moved to 1,500 feet, quite frankly, in their own local ordinances. Thank you very much.
Thank you. Thank you. Good luck.
Have a good day. Yeah, good luck is right.
All right. I think we will continue with Mr. Weiss.
Okay.
Thank you for your flexibility.
You're very welcome. I realize that you're in a difficult position when the floor lasts for so long. Anyway, Thomas Weiss again. I was talking about the claims for the proposed Enhanced Natural Resources Board. Let's see if I can get that to work. The regional members of the proposed Enhanced Board are intended to provide a regional perspective to an otherwise centralized board. And the last claim of the joint proposers that I'd like to talk to is that they claim an enhanced board would be more accessible and that the current appeals process is time-consuming and expensive. And I rebut these claims. Consistent application of criteria statewide can be achieved by more training for district commissioners, district staff, and NRB staff at a fraction of the cost of the jointly proposed Enhanced Natural Resources Board. From my experience, the current process with district commissions is fair and accessible, and the proposed appeals process is likely to eliminate an average of 3 appeals each year. And those are the appeals that now are from the Environmental Division to the Supreme Court. And that will have little effect on the time and costs of appeals for most of the people going through an appeals process. The district commissions need to be retained as recommended by the Commission on the future VET 250 and the Vermont Natural Resources Council back then in January of last year was strongly recommending supporting and keeping the district commissions. They are citizen-based, local, and have been an integral and necessary component of the success of Act 250. The hearings of the proposed board would not be local even if they were held in the municipality. The 3 permanent members would swoop in for the hearing and the hearing's over and then they head back home to their office and their homes, which are not in that area. The 2 regional members would be unable to outvote the 3 permanent members on matters of local importance if the 3 permanent members didn't see it that way. As you're aware and have been told by others, the 2 regional members would be token members compared with the district commissions only being able to work on findings of fact and not on the conclusions of the law. The proposers say they are still trying to figure out how citizens not represented by attorneys would be treated fairly and still have access. They think that can be achieved, but we know that that can be achieved with the district commissions. So the simple solution to supporting those citizens is to retain the district commissions. My experience, as I said before, the district commission was accessible and fair. I think the proposal, no, I need to follow my script. Participation at the more formal environmental division was less comfortable and a little more rigid, and I foresee the joint proposals board as also being more rigid and less flexible than the current process with district commissions. And that's why I recommend retaining the district commissions. Appeals, the justification for eliminating one level of appeal is to save time and money.
You can't find his testimony.
There were 87 appeals to the Environmental Division in the years 2012 through 2013. I used those years because they were submitted by the Natural Resources Board in previous testimony. In that same time period, there were 1,781 major and minor applications and an additional 1,077 administrative amendments. Supreme Court decisions for those same 6 years regarding appeals of Act 250 permits and jurisdictional opinions were 17. So appeals to the Environmental Division amounted to 5% of the applications, and appeals to the Supreme Court only 1% of the applications during that time period. I think it likely that people would still make appeals to the first level, in this case directly to the Supreme Court, so it would not eliminate any of those 87 or 14 a year that go to the Environmental Division. They'd be transferred to the Supreme Court instead, and the only one part of the appeals process that would be shortened would be the elimination of the 1% average of 3 a year that now go from the Environmental Division to the Supreme Court. So only that 1% of applicants would see savings in time and money for the appeals process, and that would be at the cost of having a second level of appeal. So in consistency, one of the claims is to increase consistency statewide. The report of the Commission on the future of Act 250 did acknowledge that there was inconsistency among the commissions, quoting from there, because it, being the former Environmental Board, also administered the program, it was able, through its appellate decisions, rules, and guidance, to provide consistent and unified direction to the district commissions, a consistency that has been lost by splitting those functions between the Environmental Division and the Natural Resources Board. As I mentioned earlier, inconsistency could be more easily and less expensively done through more training for the commission's coordinators. The proponents indicated it would cost an extra $500,000 a year for their proposed board, and do an awful lot of training for a lot less than $500,000. And I've done a lot of training. I've received training and I've given training over the years. And I find that telephone training is not a substitute for getting people together with the instructor, having them able to interact with each other, some during the sessions, during the breaks, and it's a much better training format and exchange of ideas. So even though the board indicates that there is telephone training, I personally have found that not to be as acceptable or beneficial as in-person training. So for those reasons, I think that, anyway, that's how I think consistency can be addressed. I believe there's an inherent conflict of interest in having the district coordinator decide which cases are major or minor, and then after having made that decision which are minor, having to deal with the minor applications him or herself. Also, the enhanced board would be able to have 3 agencies retain additional assistance, state agencies, and have costs recovered from an applicant, which would increase the cost, reducing the accessibility to applicants in those cases. For all of those reasons, I ask you to reject the proposal of an enhanced natural resources board, and all the problems with an enhanced board can be corrected, if you will, by something like the board you propose in your draft 9.2. So rather than correcting the problems with an enhanced board, I suggest that you continue working with the version that you have in 9.2 and the concept that you have in that draft. Exemption for certain transportation projects is another item. The joint proposal is to reduce the area that counts toward the 10 acres required for jurisdiction of a transportation project that receives any federal aid. They would do this by not counting the area that was previously disturbed by a transportation facility. And the justification has been that such projects are covered by the review required by the National Environmental Policy Act. I believe such an exemption will reduce effectiveness of Act 250. Exempting those projects means that abutters and other parties lose their ability to participate in the permit process. I've been involved with the federal NEPA process many years, and public participation under NEPA is nowhere near the same as it is with a district commission process and being able to have an interaction. Under NEPA, the draft environmental review or impact statement is proposed, people get to make comments one way, eventually people get, there's a summary of the comments and how they may or may not have changed the project. But with the district commissions, it's a much more direct, much more, there's more feedback. Is the word I'm groping for, and you heard some of the testimony from district commissioners and former commissioners over the last 2 days pointing that out as well. Some effects of a transportation facility are based on the entirety, not just the incremental part. Some of those effects are air quality, runoff, water quality, aesthetics, scenic beauty, or natural beauty, and habitat connectivity. It's not just the increment that affects things, but the totality. You know, you have a small, relatively narrow road, the aesthetics and scenic beauty are affected, are different for the wider road, and it's not just the incremental difference, it's the total difference. And during construction, the construction impacts are typically related to the entirety of the disturbed area. And in the example that you were given by the Agency of Transportation, you know, it wouldn't be just that incremental area that has the construction disturbances and effects on erosion and sedimentation and water quality, but the entirety of that construction site. So for those, and if the exemption is granted for federally aided transportation projects, other types of projects that receive federal aid would probably come before this committee and ask for exemptions for them too, even further reducing the effectiveness of Act 250. So for all those reasons, I ask that you reject the proposed exemption for transportation projects based on the amount of new or incremental project area. My last topic is presumptions for ANR permits. The proposal is to grant presumption to all permits of all state agencies. One advantage of the present system of determining presumptions by rule is that it requires the Natural Resources Board to evaluate each and every permit as to whether it should be granted presumption, and then the rule then matches the permit with the criteria. Non-applicant parties are placed at a disadvantage in the case of permits as presumptive evidence, because if they're not presumptive evidence, then the applicant has to provide additional documents showing why they've made their decision as to effect or non-effect or what the impacts would be. If it's presumptive, it's much more difficult for a non-applicant party to get that information to try and see whether the permit was issued reasonably or whether there is a rebuttability to that permit. And for those reasons, I ask you to reject the proposal to grant presumption to all state permits. The provisions on presumptions as proposed in your draft 9.2 are much preferable to those in the joint proposal. So in summary, I ask you to reject the enhanced board exemption for certain transportation projects, granting a presumption for all state permits, and thank you for the opportunity to share my thoughts with you.
Thank you.
You're welcome.
Any questions, committee? Representative Hunt?
Thanks for a very clear and concise document you guys.
Thank you.
It's easy to read and it's helpful. As your experience, that you said you were a civil engineer, did I
Yes.
hear that correctly? Yeah, okay. In your experience in your professional life, how often did you have to navigate Act 250 processes?
I have only been engaged with Act 250 directly once. Well, once I was a consultant to a party in an Act 250 case. I have spent a lot of time preparing documents to support Act 250 applications, doing the environmental reviews. And I have spent time preparing documents, giving training on, and reviewing the federal environmental review process.
And also in your experience, was the Act 2, the process of preparing documents and that kind of thing, was that beneficial to Vermont in your general opinion?
I think it was beneficial to Vermont. It was, I mean, what we were doing was we were preparing the documents for the applicants. So we were evaluating water quality issues, we were coordinating with the Historic Preservation Office, seeing what those documents were, and then preparing draft documents similar to what an applicant would submit to the district commission or to the coordinator to go to the district commission. But I think it was a beneficial process, and its comprehensive review and looking over all of the issues in one location comprehensively, rather than the individual A&R permits are focusing each on a separate little area, and there is not that overall review until a project gets to Act 250.
Sure.
This may be, I don't know if you've had this experience, but I'm wondering, in terms of your testimony on appeals, that under the joint proposal, there's only one appeal, and it's to the Supreme Court over a project. And I'm wondering if you've seen any evidence in terms of what the cost is of having two. Is it much cheaper to go through the Superior Court as a first bite before going on to the Supreme Court? I mean, have seen any comparison between prices on that?
I do not have any information on that. I have no idea whether it's less expensive just to go to the Supreme Court, is it on the record, or whether, I have no information.
Thank you.
You're welcome.
So committee, we have another witness scheduled. Renee Carpenter's here. What's your pleasure? We're moving in on the noon hour. We'll come back at 1. We have another witness scheduled for 1. My inclination would be to hear from Ms. Carpenter before we adjourn. Maybe it'll clear the cafeteria out a little for us too. Does that work for everybody?
Yep.
Okay. Can you please join us?
those pictures you control yourself. The other picture you just sent me, you'll have to tell me and I'll put it up.
Okay, okay, great. So my name is Renee Carpenter, and I'm a longtime resident of East Montpelier. Thank you. I'm not technologically inclined, I'm working with paper. And I want to appreciate you giving me time and hearing today. I was a party to an Act 250 case to protect a very long-term beloved swimming hole in East Montpelier. I realize you're nearing completion of testimony as a second phase to what was begun by the future of Act 250 over a 2-year process. I offered testimony to that commission, and I have resubmitted that for the benefit of this current committee process. So that's a document on the records. And I want to start by saying, we all know this, for 50 years, Act 250 has allowed for some citizens' democratic participation for preserving ecosystems and shaping the rural working landscape of Vermont. And it's really well documented in this book. If you haven't seen this book, I've linked an independent source where you can buy it or you can pick it up at VNRC, who co-published it with another Vermont publisher. And it's a lovely book with gorgeous illustrations that documents the environmental history at which Act 250 is the core. And Act 250, as you know, has served to preserve the character of rural Vermont, the working landscape, and the community-based democratic culture that we all know and love. My testimony today will refer to expert conclusions and analysis, including those from the Commission on the future of Act 250, which I'm going to try to just say the Commission, and my own experiences as an engaged participant in the Act 250 process to preserve Coburn Pond for swimming and fishing and year-round recreation. If you're interested, I can say more. I can put some photos up, perhaps. I support many of the original recommendations of the Commission and the initial stated recommendations of the Vermont Natural Resources Council, which were on their website starting in November 2018, and they brought to the State House most of 2019. And I was very upset to find that when I was looking for the Commission summary, which had been previously linked to VNRC's page, it was gone. So when I found this, and I don't know if you can post this up now to the screen, like I said, I'm not technological. This is a screenshot of VNRC's page. I want to say 4 days ago or 5 days ago, and I just wanted to capture it so it didn't disappear. To me, the fact that VNRC had amazing policy recommendations, and then they've been disappearing with this current joint proposal, it just has all my red flags waving. VNRC has been the seminal and most important environmental advocacy group in the state for this entire 50 years. It was the first when environmental advocacy was a brand new concept. And I just feel that it's important that this committee keeps that in mind as you're making your decisions. I don't know if this is still up on their website or if this is one of the documents that's been taken down. So moving on, I want to talk about protecting Coburn Pond. It's a 6-acre swimming hole. It was formed in an old sand and gravel pit where it would be illegal now, excavated into the aquifer, and it's changed shape over the years. And in order for me to gain party, I had to prove party status, and as part of that, I had to document, which I did successfully, many decades of community use of that swimming hole. It's the place where when people move away and they come back to visit, that's where they go with their friends. So it is a very important community recreation place. It's the place where the high school kids go for, swimming and fishing and healthy recreation. And so one thing I want to say, I want to stay on script so I only take my 15 minutes. VTrans has repeatedly testified about some nameless project that cost an exaggerated, and I will say an exaggerated amount of money. I've heard that they've called it the poster child for why they think Act 250 should be weakened, why they think Act 250 shouldn't have oversight for federally funded projects, and as the previous testimony described, why they're asking for all of those things. Well, protecting Coburn Pond is that project, and I agree that it is a perfect poster child, but it is a poster child of why and how important it is that Act 250 can and should work to benefit the public and the environment, and I'll say more about that. But some of what I discovered through the Act 250 process, and so I started cold. I knew nothing about it. I got involved in 2005 in my town permitting process and was advised then to seek party status through Act 250. Decades of citizen opposition before I got involved in 2005. VTrans wanted to fill in to create constructed wetlands to mitigate for wetlands that would be destroyed during highway expansion that they call Route 2 Cabot-Danville. It was 4 highway segments, but starting in around 1983, so these are things I discovered as I'm trying to figure out how to make Act 250 help to protect the swimming hole. That's all I knew is Act 250 could help us protect our swimming hole. But in 1983, there was a group of citizens who were opposed to expanding what was Highway Segment 1 on Route 2 across the Marshfield Reservoir, and they had very well substantiated ecological reasons in addition to aesthetic reasons, because if you ever travel just north of Marshfield where they expanded Route 2, they took out the whole buffer of trees. So now anyone who does recreation on what is called Molly's Falls Pond, no matter how far down the water you go, you hear Route 2 highway noise because there's no longer a buffer of trees. But that's not why this group of citizens was opposing it. They were opposing it because of ecological reasons which are beyond my purview. But they contacted me and they helped get me up to speed on how to use the Act 250 process. But remember, this is going back to 1983. I started in 2005. The professionals who were supporting the group, the citizen group, that initial citizen group, they believed that the VTrans project, which actually was an expansion of Route 2 from Montpelier to Danville, that citizen group, which include lawyers and planners and people who are still involved in those capacities, they believed it should have gone through the federal NEPA review. And I later learned that developing the project in segments the way they did allowed VTrans to allow that legal requirement of a NEPA review, which I've also recently learned is a strategy that's used all across the country. It's not specific only to VTrans. But that's something, like when they come out and they're all paid to come out here and tell you various things, it's like, this is what I learned from the Act 250 process. The other thing I learned with help of various other volunteers and pro bono professionals, we went through VTrans memo documents, and going back to the 80s, they have to do weekly memo documents when they meet. Those documents going back to the 80s revealed that at almost every time Coburn Pond, as we call it now, they called it the old gravel pit or the Caledonia Quarry and many other things, but every time that came up, as a possible site for wetland mitigation, someone in the working group asked or said, but isn't that used as a swimming hole? And the reply in those memos was very consistently, oh, don't worry about that. 1983. So, given that VTrans knew of existing public use as a swimming hole going back to the 80s, whose fault, and they knew about the opposition to Highway Segment 1 at least, whose fault is it that the public opposed the filling in of the swimming hole that had an existing use? They did not want to see it filled in to be a constructed wetlands. So every time you hear from VTrans how much money this case cost, and really it's the Vermont taxpayers who are paying for it, please remember they knew about public opposition to the highway expansion that would require wetland mitigation, and they knew about the existing use of Coburn Pond as a swimming hole. They knew these things back in the 80s. The initial permit application was denied based on the outcome of citizen action that where groups of people helped me as the party. It was denied as proposed for 4 highway segments that would have required a filling in of the swimming hole plus constructed wetlands south of the existing pond. VTrans believed that they could power through the will of the people, and that's what cost so much money, because in the end, instead of, and here's another thing that I think is relevant to what you're discussing today and through your process. In the end, instead of a full appeal, the environmental court ordered that a negotiated settlement be reached, because we didn't have the hundreds of thousands of dollars to do an appeal, and we wouldn't have the hundreds of thousands of dollars to appeal it to the Supreme Court either. But because we went through environmental court and because we had very wise pro bono legal counsel, we were able to negotiate a settlement agreement, which was, I believe it was like $2,500, which we were able to do with the support of VNRC's water quality attorney, that was John Groveman at the time. Just little details of history that might be helpful to understand what's going on right now. So, through this negotiated settlement process, we had 2 very lengthy facilitated negotiations. We agreed, because we had successfully protected the swimming holes, we all agreed that because VTrans wanted to build Highway Segment 1, they were finished, they'd been fighting that with opponents since the early 80s. So we agreed that for only Highway Segment 1, they could construct wetlands south of the swimming hole, the pond, Coburn Pond. The negotiated settlement became the permit through environmental court, and it was specifically designed to protect the water quality and existing use of the pond and to protect the shoreline while allowing for a limited amount of constructed wetlands to compensate only for Highway Segment 1. So I want to reiterate that Route 2 Cabot-Danville, Coburn Pond, that project is in fact the poster child for Act 250, and it's the poster child that illustrates exactly why district commissions need to stay in place, why enforcement reviews and remediation needs to be adjudicated outside of the purview of government agencies, and I'll talk about that in a minute, and why Act 250 needs to remain strong and located by the commissions in the communities where the projects exist. And also Act 250 needs to be very strong in empowering citizens to protect natural resources in their communities, because we're protecting our communities and we cannot be persuaded or manipulated by political process. Political process is very transitory, but our landscape and our natural resources once they're destroyed, they're gone. So it's very difficult to manipulate people who are protecting their home base. Also, government agencies have large budgets and they have a singular focus, and they need to account to the public that they are supposed to be serving. VTran's repeated testimony using this particular case as a reason to weaken Act 250, it illustrates every time they do it, I want you to remember how important it is for you to strengthen Act 250, to empower the public. It's our tax dollars being wasted. And I'll tell you, every time I showed up, you can tell I'm nervous now, I was nervous. This was a very painful process to go before a friendly commission and a dozen paid professionals who came to represent the Agency of Transportation and the Agency of Natural Resources, and sometimes the Army Corps of Engineers. It was a very difficult process. Okay, moving on. Enforcement issues are not, yes, I'm close. Enforcement, and I have written testimony and you have access to it.
We have the written testimony, so I just wanna, we do need a break for lunch and
I'm
come
hungry
back at
too.
1, yeah.
Yeah. Enforcement issues are not addressed in the proposal. And I don't have to tell you what the enforcement issues are. I've summarized them very briefly, and they're very important. The NRB has been ineffective and unwilling to meet its obligations to enforce. I can tell you more about that. I know you hear from the NRB, and I know you've heard expert testimony that says similar things. The district commissions are the heart of Act 250. In my testimony, if you look at it online, I've linked you to VNRC's original content. They made wonderful suggestions for the fall of 2018 and the 2019 legislative session. Those are the recommendations I think you should follow, as are the recommendations that came out of the Commission on Act 250. And finally, regarding appeals directly to the Supreme Court, the Commission on the Future of Act 250 wrote, and I quote, "The Commission has not received any testimony supporting other options," which you can read of what those options are, "such as the appeal to a generalist rather than the current specialized court, or direct appeal from the district commissions to the Vermont Supreme Court," which is what you have in this proposal. The Commission wrote, "The Commission does not support these two options. In particular, direct appeal from the District Commission to the Supreme Court would likely cause increased formalization of the District Commission with a resulting loss of accessibility to citizens." Let me highlight the resulting loss of accessibility to citizens, both by appealing directly to the Supreme Court and also the elimination of district commissions. And finally, I've already begun to express it, I have very deep and serious concerns that the recommendations by the Commission are being overruled for political reasons. The final report of the Commission offered serious consideration, analysis, explanations, and recommendations that should be at the core of the current process. I'm concerned that the current legislative committee, you, which have less time and depth of focus to examine this law, even though you're doing an amazing job and I appreciate it, yet the Commission focused on it exclusively for 2 years, including the summers. So I'm very concerned that this law that has preserved the state that we love, that is unique across the country in our approach to environmental protection, and our success in doing that, even in the face of what's happening in Washington for the last 3 years, that you might be rushing to complete a process that is being manipulated by political undercurrents. And so please read my testimony. I want to also point to the testimony that you've heard in the last several days of Ed Stanek, Carl Johnson, Tim Taylor, involved in Act 250. They articulate technically some of what I can secularly express. And also environmental advocates Annette Smith and John Brabant. And I particularly appreciate John Brabant's proposal to institute a fund that supports citizens to become parties and engage in the process. It is perhaps one of the most important aspects of Act 250, and it goes beyond Act 250 because, as some of the people who have offered me grant funding have asked and have found, all of the people who have supported me as a party in this case are now far more fully engaged in their local governance, their local democratic process, in interacting with their communities. This, one could say, is also at the heart of our citizen-based democracy in Vermont. And so for all of these reasons, I hope you will take to heart my testimony. Thank you very much for your time.
Maybe you have questions?
Thank you. Thank you.
Thank you.
All right, we will adjourn for lunch. And we'll be back at 1.
So do you part of the River Conservancy?
We are communicating with the Vermont River Conservancy moving forward. And so from this process, post-Act 250, once we get Act 250 enforcement to enforce, there's an enforcement issue pending. But once that's done, we want to work with the Vermont River Conservancy
I urge you to do that.
to preserve it. So we've had these conversations, we just can't move forward until we get enforcement. Even though we've done everything, we have not been able to get the natural resources board to enforce. So I'm encouraging you to move away from a state-run organization and go back to an environmental board that's a citizen board. Thank you.
Oh, yeah.
And I'm not the only one. The fellow who left wanted to give some testimony from, I think he said Albany. I don't know him. I met him through this.
Well, we'll just hang out outside and keep whatever you want. That's fine. We're gonna be here.
He has a different story, and his testimony is online, so it's worth looking at.
Thank you very much.
Thank you.
1:30 side by side.
Second
Oh, yeah.
time.
You guys can have a ride on this.
All right, we'll call our meeting to order. We will welcome Chair Snelling. Okay. Excuse me there, sir.
Yep, we got it.
So, as I was leaving, Representative Dolan had some questions for me, and I think the first one was Diane Snelling, for the record, Chair of the Natural Resources Board. But before I get into that, I just wanted to review some basic facts. That currently the board consists of me as the chair in a full-time position and 4 volunteers. We meet once a month, generally by phone, and just recently we've agreed to have meetings monthly, and they have expressed an interest and have proceeded to vote on the budget, certain policy issues and legislation. But there is no task in front of us as a board. There isn't anything that we have. I mean, there's jurisdiction, but it has been delegated to me in the day-to-day. So for the board itself, there isn't a compelling reason or discussion other than to review the things that are in front of you as the legislature and other issues in terms of what they do. So going back to your questions,
Diane,
yes.
on the topic of the board, someone mentioned, I think yesterday, that ENotes really haven't been used since the change in 2005. I guess.
Oh, well, I don't think
I mean,
that's entirely
added
true.
to. They haven't been added to. And I'm wondering if that's true, and if so, why, and if you could help us understand that.
I think I will defer to Mr. Bogle.
So, the ENotes, we add to the ENotes whenever there is a case that comes down from the Environmental Division or the Supreme Court involving Act 250. So I don't know where that testimony came from, but it's updated yearly. So every year we go through all the cases that had been issued either by the Environmental Division or the Supreme Court, and we update the ENotes.
And are those searchable by subject or?
There's a pretty extensive index, and you can obtain the ENotes in either a Word form, Word document, or PDF. So you could do a word search, or you could look at the extensive multi-page index to try to find the subject area that you're researching. We could pull it up if you'd like to see it at some point.
Did you want to add anything, Evan, or? Okay, Mr.
Just a small footnote. I heard Commission Chair Taylor's point about the ENotes to be, it'd be wonderful if there was a way that the commission members could access via ENotes decisions by other district commissions. So they could compare notes what other commissions are doing on decisions under the criteria as organized by ENotes.
That makes sense, and that is, I think that we're likely not going to ENote basically summarize every district commission decision. I don't foresee that happening anytime soon. But our new database that I think is supposed to be rolled out in sometime in the not too distant future, there's a way to, there may be a way to search by subject area, which might provide some assistance that way. It would certainly be a nice feature. I just don't know that we have the capacity to do that right now.
So Evan Meaner from the Natural Resources Board. I would just also go back and reference the statute, which I think says that the board has the authority to either publish its decisions or contract with someone else for the publication of its decisions. The ENotes was the free version of those two options in order to make this information available to any member of the public who doesn't want to pay for the service. That said, there are commercial services available that people can pay for that will give them word searchable access to all of the old environmental board decisions and the environmental court decisions. And attorneys who participate in Act 250 cases presumably have purchase access to that, and a citizen could as well.
Well, I guess we're also talking about district commissioners having good access, and so perhaps we should purchase that for them if there's a better way for them to access the notes. I mean, asking them to both volunteer their time and then expend money to research seems a bit over the top.
Well, which is why they have access to the free ENote service, which is almost 100 pages, if not more at this point. 500 pages at this point. And they have access to 2 full-time attorneys who can research any legal question that they have.
And do you?
Yes.
Thank you.
So I think you asked me, Representative Dolan, kind of to give you some input on about the commissions versus the board and kind of what was the rationale.
Yes, I had 3 questions. One question was the joint proposal we have in front of us recommends a reduction in the number of district commissions. And why is that? What if you have an understanding for why that is in the proposal? The second question is, if we were to move 2 of the regional members to the E-board, to the enhanced board, to join at par with the 3 members at large, what would the marginal cost be substantial, or what would be that marginal cost of doing that? And then the third question is, we had heard concerns about the Natural Resources Board playing 2 roles, one as judge and one as advocate in the appeals process, and where you saw the lessons learned from that, and how to would this joint proposal we have in front of us help to eliminate that potential conflict?
Okay, I'll try to see if I can answer them. First, on the issue of the commissions, eliminating the commissions, I guess I am tending to think about the positive benefits of the board, and have been telling myself to think of it as 5 versions of the board. In other words, you have the 3 members, and then you have the 2, whether it's 10 districts, 5 districts or 6 districts, you basically would have 2 from each of those, so you would have 6 versions of the board or 5 versions of the board that cover the state. So I don't think that answers your question about why eliminate the commissions, except that I think there's a presumption that these 5 versions of the board could cover many of the same issues and perspectives that the commissions do. And in my opinion, having a board that is more statewide in its outlook would be very positive in terms of collecting the kind of data that we need to have to be making decisions that are informed by all developments and environmental impact statewide. So that's very appealing to me in the sense of really having a place to locate all of that information and knowledge about ongoing development and environmental impacts, which I don't know that you really get from 9 different districts. There's no place where it's added up, if you will. I don't know how to calculate the additional costs because we haven't, until you all make some decisions, it's a little hard to say what the costs will be. In other words, if you make the regional representatives part-time, what will you decide to pay them? So that's really more of something that you're going to have a discussion about than I have an immediate answer for, if that makes sense. It's entirely possible, I think I gave you an estimate of $500,000, and that's very rough, and it's entirely possible we could do it for substantially less. As I said, it's a little hard until things kind of settle down and you can sort of calculate it out. As far as appeals, I talked a little bit with Mr. Boble about that, and I think he's better able to give you that in legal terms to respond about different perspectives on handling appeals. But I did want to ask if there were any other questions.
Good afternoon.
Hi.
The 2, I don't know what else to call them, the commissioners or civilians who would travel with this professional board, are they picked from the place in which the project is aimed at?
Yes.
So they would always be changing?
Yes. I mean, I think if you look at how projects happen geographically, the majority of majors happen in Cheatham County. So I don't, I'm just saying I would think that in general they're going to be there more than they're going to be some of the other places. But
if something is happening in District 7, people who are sitting with the board will be people from District 7?
That's the idea, yes. So fulfilling some of that role of having a local perspective. And I guess you could think of it as having the best of both, that you have a local perspective and you have a statewide perspective.
Is the analogy the lakeside judges in terms of sitting and listening and being there?
No, side judges to me have always been a difficult situation because they're looked at as, I guess it depends on how you feel about side judges, but I've never heard them referred to as particularly helpful. And so I would hope that they would be more helpful than side judges. Not to offend anybody who's a side judge, but.
Any other questions for Madam Chair?
So, Greg, did you want to speak to appeals?
Sure. So, current status quo system, when an appeal is taken from either a district coordinator on a jurisdictional opinion or from a district commission on a permitting decision, the matter goes to the Superior Court Environmental Division. The Natural Resources Board is authorized by statute as a party of right for any of those appeals. So we have the opportunity to participate in any of those appeals if we choose to participate in those appeals. There's no requirement that we participate. As a matter of practice, we participate in virtually every appeal that is taken from either the coordinator or to the commission, or from the commission. The extent that which we participate might depend on the issues that are appealed, the complexity of the issues that are appealed, the parties that are involved with the various appeal, the legal issues that are presented. And we take all of those factors into account when the board makes a decision as to whether or not we are going to participate in the appeal, and to the extent that we're going to participate, and the position that we may take on appeal, which from time to time may be different than the position that the district commission and or district coordinator made in the first instance. We're not required to defend, so to speak, the position that the coordinator or the commission took, and again, sometimes it's the prerogative of the board to take an opposing position. Some of that might be traced back to the fact that these appeals to the Superior Court are de novo. So the Superior Court hears all the evidence again that the district coordinator heard or that the district commission heard. And sometimes, because of the de novo standard of review, there may be additional evidence that wasn't heard below. The project or description of the project, if it's a jurisdictional question, may have changed slightly. And so sometimes there may be a different perspective based on the same set of facts that the board may take, as opposed to the position that was taken below. So that's sort of how the current process works. And just to give you some background, this past year in 19, there were 14 appeals, 8 from the district commissions, and 6 from jurisdiction opinions from the district coordinators. That's roughly a reasonable average number over the course of the last 5 years. There might be a slight downtrend in the number of appeals that are taken, but very generally, somewhere between 10 and 17 or 18 appeals. The proposal that's in front of you would significantly change the way in which the board participates in appeals. Rather, the board, in the first instance, would be hearing permit applications for majors, and those appeals, should there be an appeal, would go directly to the Supreme Court, and the board would not have an opportunity to participate before the Supreme Court to advocate in support of its position. So we would know, like the attorneys on staff would no longer be acting as an advocate one way or the other in front of the court. Rather, we would be staffing the board and helping it, doing its legal research. We would be helping it to draft decisions. We'd be helping it to understand evidentiary issues that may come up from time to time. Those sorts of things. So our role as attorneys would likely change, or would change very significantly. And, well, of course, you know, the board's role would change significantly as well. Instead of determining how and when and why to participate in appeal, it would be making permitting decisions. Maybe, I don't know if Evan, if you have anything to add to.
No, that's a pretty accurate summary of how things work now and how they will work.
And that would be, so then the board would be working on the record and the Supreme Court would take that record.
That's correct.
No new evidence would be introduced.
There may be very rare circumstances where the Supreme Court is allowed to take new evidence, but I don't think that would be the norm. It would certainly not be the norm.
Oh, we had heard from a witness from District 5 Commission, Jocelyn, I can't remember her last name, and she talked about how she's in a very busy district, and how occasionally the role of the presentation of the case at that district commission level is expensive for parties, and because it then moves, if it's appealed, moves into the next phase, as a de novo standard process, that all that work in sweat equity is, in her words, recycled. Has there been any thought of just tweaking or changing the existing process to not have a de novo process, have it on the record process as a change in that existing structure? And that may put greater value at the district commission level? Has there been some?
I think there has been, and at the same time, it's recognized that it might be very difficult without additional staffing, et cetera, to help district commissions do that, which is the basic difference between what is seen here as a statewide board or the professional board hearing that versus the commissions. So it's about capacity to some extent, and if you disagree, please say so, but.
Because, may I follow up on that? Is it because the expertise may not exist at the district commissioner level? To be able to be, knowledgeable enough or know how to find that information to warrant a decision?
I think creating a valuable and accurate record is different than having the kind of hearing that we have now. So people who have been conducting the hearings as we have now, it would be a substantial difference, but you're not going to have it at the commission level. So, I can't personally see how that kind of functions, that if you created, I will tell you that for years, people have been asking for commissions to create on-the-record review, but in a sense, it doesn't work unless you create this other level, in my opinion, but because of the, just as I said, the capacity to create that record in a thorough way.
And just to clarify, so if I may clarify that, then that extra level you're talking about, what's being proposed here, a statewide board of sorts?
Mm-hmm. So before I leave, I just wanted to thank you all very much. Representative Dolan said sweat equity, particularly to you, Madam Chair, for your persistence in pursuing the importance of the potential changes to Act 250. Act 250 means a lot to Vermont, and I think if you all can come up with the right changes, it will continue to have a very positive impact on Vermont, and we need it too. So thank you for your work.
Thank you for your time.
Representative McCullough.
Thank you, that was an awesome closing speech. I got my foot in the door just before you left. Imagine on the record at the district commissions. What capacity would you recommend that they have in order to be able to produce on the record?
Well, it's about the evidence. It's about how do you create the record? And again, Greg, please, if you can articulate this a little bit better, that to have a record which will be substantial enough to go to the next level, it needs a certain kind of thoroughness.
And so I'd be asking both of you, but that would be accomplished with each district having an attorney available to assist it during those moments of testimony and after?
I think that would be helpful. I mean, I guess there's a few different ways to accomplish that task if it's something that the committee was interested in exploring. And this is certainly not exhaustive. I'm just thinking of this as, but certainly if, for instance, if one of the commissioners was an attorney, if the commission had more access to a staff attorney for hearings, I would imagine a certain level of additional training on evidence in matters of civil procedure would be helpful. Mm-hmm. It becomes much more technical when you're holding an on-the-record hearing as opposed to the type of hearing that the commission's currently hear. So I think that a certain level of expertise might be necessary in order to achieve that task. Additional training might be necessary to achieve that task. Probably some additional funding in order to get an actual typed record to a stenographer, which is a cost that would have to be included in the current proposal for the board on the record hearings.
Yeah.
So yeah, those are some of the things that can get you there. Then of course, in many ways it would mirror the needs of the current professional board that we're talking
Yep.
about at the board level.
Thank you.
Yes.
And in that list, you included, I imagine that would mean compliance with the Administrative Procedures Act?
Civil procedures, evidence, we always have to comply with administrative procedures. But during the course of the hearing, there might be matters of civil procedure, there might be matters of evidence that would come up that would have to be ruled on one way or the other, which currently, in the current system, there's a lot more flexibility afforded to both the applicants and to neighbors to present their case as they wish. In so doing, you don't create an appealable record to the next level, to the Supreme Court, if that next level were to hear the appeal on the record.
Evan Meaden from the Natural Resources Board. So I think what Greg summarized is accurate in terms of the additional steps you would have to take to make on the record happen. And I think we can take those steps if you thought it was a good idea. But I did want to just state something that I don't think was stated, which is how the actual standard would change. If we're not doing de novo, what are we doing? And I just wanted to put out there that the most likely alternative would be that you would be reviewing, you wouldn't be reversing district commission's factual findings unless they were clearly erroneous. That's the phrase you see kicked around in other contexts. And then the conclusions of law would be reviewed de novo, meaning brand new, which means that there would likely not be new evidence and there would just be new legal argument. So I just wanted the committee to be aware of what the actual standard shift would be.
Say that term one more time.
So it would be, instead of reviewing everything de novo, i.e. brand new, you wouldn't reverse the factual findings unless they were clearly erroneous, and then you would review the legal conclusions brand new de novo.
At whatever level it appealed to.
That's right.
Representative Odie then will come up.
But then what if you didn't know that you should have put something into evidence?
Okay, so I don't remember if you remember having a conversation where I think I thoroughly confused everything last year when Ernie Pomerleau was in the room and we were talking about the presumptions of afforded A&R permits. And what I was trying to articulate was this thing called the new evidence standard in the rules of civil procedure. And what that says is, if you've got a trial in the civil court, right? Someone hit you with their car or something like that, and you have a trial, and you want to have another trial because you think a mistake was made, and your evidence that a mistake was made was this new piece of evidence. In order to get a trial, you've got to come up with a darn good reason why you didn't have access to that evidence the first go around. In other words, it didn't exist. It wasn't available to me. I just discovered it, and there's real reasons why I couldn't have discovered it earlier. Some real explanation for why all of a sudden we're in this place where we're talking about this new thing. And if there is a good reason, then the answer is, oh, okay, well, great, yes, let's take that new information and see whether or not it changes our decision.
But I think if I asked that question, that what I was trying to get at, what I'm getting at here is, if you've got citizens and they just didn't know they needed something.
Yeah, they'd have to come up with a good reason.
That's just not, all right. Actually, that's a pretty good reason. They're citizens and they didn't know they needed it.
What's your standard of evidence?
Yeah.
Pretty good.
I mean, what are we talking about? Are we talking about, well, I'm a citizen and I didn't know that I should have shown up with my own wetlands delineation? Or I'm a citizen and I didn't know that, like, if I had snapped a picture of what my backyard currently looks like, that would have made a difference. You know, so are we gonna say in front of a district commission, a citizen who didn't show up with all the pictures of the deer tracks in their backyard gets to now come with 200 new photos of all the deer tracks? Or, you know, or should they have known, bring your photographs with you to the district commission? So there's all different types of evidence that could be relevant. And how much do we want people to have a second bite at the apple? That's a big question for you all to answer.
Representative McCullough, you remember saying?
I think I'm holding, thank you.
Okay.
Good.
I had one that you guys aren't going away though. I lost one. I was gonna ask you about testimony we took earlier today. But, thank you,
Less is more.
Madam Chair.
Thank you.
And Representative LaFave has a written submission from someone who wanted to testify and couldn't come yesterday and wants to read it. It's not very long.
This is from the commission, the head of the District 7 Commissioner, Eugene Reed. And he asked me to read it because he's a school teacher and he couldn't get down here. He teaches in Canaan. And his letter says, "Hello, my name is Eugene Reed. I chair the District 7 Commission, the Northeast Kingdom, and have served on the District 7 Commission for over 20 years. I have read through some of the proposed changes to Act 250. While I do not yet fully understand the very recent proposal by VNRC and the administration, a few things stand out to me that as a resident of the Kingdom I would disagree with, and I would say that my neighbors would also not want to see. Elimination of the district commissions. I feel this completely erodes the intent of Act 250. One of the keystones of Act 250 is place-based decision. What fits in Chittenden County may not be a good fit in Essex County, and vice versa. Would we want people in Texas making decisions for Vermont? It is important to keep locals in charge of local decisions. It is also important to ensure that Act 250 process remains accessible and user-friendly for the general public. In the Kingdom, we have many towns without zoning, many small businesses, and applicants and neighbors who apply and participate with assistance from the district coordinator, often without hiring attorneys or engineers. It is my understanding that the PUC process is not user-friendly to the public. As such, it should not be used as a model for a revised Act 250 process. The current district commission process, in my opinion, works well and should be left alone. Thank you for considering my testimony, Eugene Reed. Thank you.
Right, committee. What do you guys wanna do? Go home Friday afternoon, that's why we're talking about it now. So, we have taken a lot of testimony on a proposal from VNRC and the administration. We spent a lot of time talking about the board structure because it's the biggest substantive difference between our proposal and the one that they've brought to us. And I guess I'd like to have a conversation about how to move forward, how people are feeling about the big proposed changes. I guess I just would like to remind the committee that, you know, the base that I'm operating from really is the bill that we were working on last session. That's the foundation that we're at here. And, you know, that we've been given this alternate or, I mean, it addresses many of the same issues, and we've got great tables and charts from Ellen to help us understand the pieces and parts that overlap. And but at the end of the day, I think we need to make some decisions about, are we ready to make changes at the board level? And if so, generally what direction are folks feeling that they want to move in based on the testimony we've heard so far?
Well, Madam Chair, are we getting a side-by-side, a more complete one from Ellen? Did you request that? last time out. We're gonna see more.
Well, there were some sections that weren't in the last side by side, is that what you're talking about?
Yes.
Yeah, Ellen, did you make those changes? Okay. Yep, is that what committee wants? The, finish the side by side.
I'm thinking we could just go back to this really simple sheet that we have.
I think, so, let's have Ellen remind us of, what's remaining in the detailed side by side that we did not look at the other day. And then I think, Carol, yes, we will use one of the tables that, I'm glad you think they're simple.
Well, it looks more simple
It
than
is,
this.
yeah, no, it is. And, the other thing is that Ellen, I think, prepared a list of what's not addressed in the administration VNRC proposal. So let's hear from Ellen.
Sure. Ellen Tchaikovsky, Office of Legislative Counsel. Yes, I have 2 new sections to add to your other side by. It's just 3 pages. It's two proposals. It's related to interchange areas and then burden of proof. And so,
Yeah.
Yeah.
I think for side by side, we should just get it for everybody. Yeah, we'll do that henceforth. Yeah. Okay. And it's on the webpage.
it's on the page, and then I do also have the list of things that are in your bill that are not addressed by the joint proposal. And so,
Screen's asleep.
the screen is asleep. I'm sorry, Mark, that you're running around. Thanks. All right. So, in regards to interstate interchange areas, your bill currently consists of a sort of 3-prong approach to protect the area around interstate interchange areas. So first, we have a definition of interchange area. There's also a jurisdictional trigger, and then there's also there's also a new criteria, and then there's also a new permit denial standard. So I'll go through those with you.
And the committee bill is on the right.
The committee bill is on the right, yes. So new definition in the definition section, interchange area means the land within a 3,000-foot radius of an interstate interchange, except for land within an existing settlement. The radius shall be measured from the midpoint of the interconnecting roadways within the interchange. Development means each of the following: the construction of improvements for commercial or industrial purposes in an interchange area unless it is within an existing settlement. Now, so there's also a new criteria. This is criteria 9I. Interchange areas. A permit will be granted for a development or subdivision within an interchange area when it is demonstrated that, in addition to all other applicable criteria, the development or subdivision complies with the Vermont Interstate Interchange Planning and Design Guidelines applicable to the category of land use as identified for that area in the regional plan. As used in this subdivision I, Vermont Interstate Interchange Planning and Design Guidelines refer to the guidelines by that name published by the Agency of Commerce and Community Development in 2004, or such update to those guidelines as the Commissioner of Housing and Community Development may subsequently publish, provided that the update is at least as protective as of existing settlements, scenic beauty and aesthetics, farmland and natural resources as the 2004 guidelines. So, bless you. You may recall that there is an existing document. It's got a lovely cover with the sprawling lands, and the agency had produced it, and it has a sort of scale of A through F, and all of the interchanges are sort of fall into one of those A, B, C, D, E, D, category based on how much development and what the land type is, and then so each is already categorized, and then there's sort of related appropriate land use for those areas is described in the guidelines. So there's an existing framework, and it there's sort of a suggestion that they be updated, but there is an existing framework in that document.
Question?
I have a reaction, but I don't have to say it now.
Okay.
I do have a question though. Where's Howard Dean's letter, what executive order, whatever?
It's in that book right there.
It's
Could you?
It's
So
also,
what's your
The
point?
executive
Yeah.
order?
it was also filed
I
in
wanna know if it's
testimony
more
last year.
strict.
How does it relate to this?
Okay, so I haven't fully analyzed it because so the executive order does not have a it doesn't have like a 3,000 foot or 2,000 foot radius statement in it. It just says the areas around interstate interchanges, and it directed the agencies to do certain things about that, and so I can get back to you on that. I have been researching it, but I haven't. The agencies had guidance that they were using, and I haven't found that yet.
I think it was filed last year.
Yeah, I think Chris Cochran has it somewhere or other.
But mostly, I am gonna say something. It's not just about the number of feet, it's about what you see. And if you're driving on Interstate 89 and you're driving north and you see farmland and you see, not like Connecticut, and then you look to your left and there's this beautiful UVM farm and farmland. I'm from Connecticut, so. And there's this beautiful farmland here. And then even when you get off at the exit, used to be, even the Sheraton makes its buildings look like a farm. And we finally got the Gaines huge big sign that used to be up high down. And look at what you see to your left. Doesn't matter whether it's more than 3,000, less than 3,000, that doesn't matter. What you see are multi-story residential units that completely kill the feel of Vermont. And I want to say that. I do not want to see that anywhere else, personally. So I need something that's going to prevent that from happening in other places.
Sure, that's great. Let's see what else that something could be.
All right.
Excuse me. So the other provision of yours adds a new reason that a permit can be denied. So under 6,087, a permit may not be denied solely for the reasons set forth in criteria 5, 6, and 7.
Don't take it personally, Ellie.
One more time. Maybe, Jim. Thank you.
So 5, 6, and 7, reasonable conditions and requirements allowable under subsection 6086C of this title may be attached to alleviate the burdens created.
There it is.
Bless you. However, a permit may be denied under criterion 5, so traffic, if the permit is for development in an interchange area that is not within an existing settlement. So currently you can't have if there are undue burdens under traffic, municipal, or education services, the permit can't be denied solely for that reason. But under this, if it's within an interchange area and there is a burden on traffic, now your permit can be denied if that's not mitigated.
Yeah.
What is an interchange area? Is it exit and access?
It's the area around an interstate interchange. So yes, where two interstate roads cross.
The midpoint of the interconnecting roadways. Within the interchange. I think that's the crossover bridge. The middle of the thing that goes over the interstate.
So it's limited to an interstate highway.
Limited to a limited interstate. I mean, do we have other, Route 7 has some limited access areas. Would it apply to that? There's exits on Route 7. But it's not an interstate, I don't believe.
It's not it's not this is just interstate, so things that cross the interstate.
I was wondering about the history of section 6087, if Ellen or you or anyone in the room knows. Why have those criterion called out?
Where were you in, sorry?
On the second page for a denial of application, it's actually got page 30 up in the corner. Does anyone in the room remember or know why just those three are called out as you can't deny the permit for just those? No, okay.
No, I think that goes way back. I don't know the answer. It's older even than me. I don't think so.
All right, Representative Matella, do you have a question?
Thanks, guys.
Yeah, well, more of a, what I believe is a correction to what I think I heard. In 600147, on our page 29, interchange area means the land within 3,000 foot radius of an interstate interchange. And an interchange, I don't think is defined elsewhere, but I think it absolutely means ingress and egress to and from the interstate versus an overpass.
Well, I just was saying that the radius shall be measured from the midpoint of the interconnecting roadways. The second sentence in the definition is what I was referring to, where you measure that to define your interchange area. Is, I think, what that's talking about. The midpoint of the interconnecting roadways is the overpass.
Were you getting to the point around interstate interchange? Is
Yes.
that what- Because if you go down Route 7, there's a couple areas there, but they're exactly like interstate interchanges.
Yeah, that was my point.
So
They should.
it's not just interstate.
We need to look at, think about that.
agree.
And then there's no definition, I think we're gonna get to the joint proposal here in a second. There's no definition added on their side for interchange area, or is it the same as?
There is, it's embedded in that, their long language. They have it structured differently. So they have added a jurisdictional trigger, and in there is a sort of definition. So in the joint proposal, development means each of the following: the construction of improvements for commercial or industrial use within 2,000 feet of a point of access to or exit from the interstate highway system, as measured from the midpoint of the interconnecting roadways, unless a regional planning commission has determined, at the request of the municipality where the interchange is located, or any municipality with land in the 2,000 foot radius, that municipal ordinances or bylaws applicable to properties around the interchange ensure that planning development patterns will maintain the safety and function of the interchange area for all road users, including non-motorized, for example, by limiting curb cuts and by sharing parking and access points, and parcels will be interconnected to adjoining parcels wherever physically possible. Ensure that development will be undertaken in a way that preserves scenic characteristics both at and beyond the project site. This shall include a determination that site and building design fit the context of the area. Ensure that development does not destroy or compromise necessary wildlife habitat or endangered species. The uses allowed in the area will not impose a burden on the financial capacity of the town or the state. Allowed land uses must be of a type, scale, and design that complement rather than compete with uses that exist in designated downtowns, village centers, growth centers, or other regional growth areas. Principal retail should be discouraged or prohibited in highway interchange areas. Development in this area may not establish or contribute to a pattern of strip development. Where strip development already exists, the development in this area must be infill that minimizes the characteristics of strip development. Site design must use space efficiently by siting buildings close together, minimizing paved surfaces, locating parking to the side and rear, and minimizing the use of one-story buildings. The allowed uses, patterns of development, and aesthetics of development in these areas must conform with the regional plan. The allowed uses, patterns of development, aesthetics of development in these areas must be consistent with the goals of 24 VSA 4302.
So they've come up with a list of 10 new criteria for interchange areas.
Yes.
Got it.
It doesn't include residential either, but neither does our side.
Seems complicated. Okay. Any questions on this? You have a comment?
No.
Okay. Alright, burden of proof.
And then these are the different proposals for burden of proof. Yours is on the right, so you may recall that we added some language to hopefully sort of make it more clear. So it's now burden of production and persuasion. So the initial burden of production to produce sufficient evidence for a district commission to make a factual determination shall be on the applicant with respect to criteria 1 through 10 of this title, so all of the criteria. The burden of persuasion to show that the application meets the relevant standard shall be on the applicant with respect to criteria 1, 2, 3, 4, 8A through C, 9 and 10 of this title. The burden shall be on any party opposing the application with respect to criteria 5, 6, 7, and 8, not including 8A through C, that of this title, that the application does not meet the relevant standard. So this is saying that the application has the burden to show 1, 2, 3, and 4, so air and water, soil erosion. 8A is necessary wildlife, B is forest blocks, C is connecting habitat. Then we have all of criteria 9 and 10. And then a party opposing the application has the burden of persuasion for traffic, municipal and educational services, and 8 is aesthetics.
And just remind us, production and persuasion.
Production is that you have met all of the initial you have enough to complete your application, and then persuasion is if you have met the actual standard to prove, like undue adverse impact.
So production is the facts of the evidence before us?
I'm gonna ask for help if someone behind me has a better articulation of it.
I think that's pretty close. I think the idea is to produce enough evidence for, the production is the question of whether or not enough evidence has been presented to the commission to make findings. The question of persuasion is whether or not arguments have been made sufficiently to persuade the commission one way or the other.
I love when legal terms are straightforward. Okay.
And these changes were part of the discussion around changing the burden with respect to necessary wildlife, particularly, who has control over the data and information necessary.
Okay. And theirs, joint proposal.
So for the joint proposal, the burden shall be on the applicant with respect to subdivisions 1, 2, 3, 4, 8, B and C, 9 and 10. So and then the burden shall be on the party opposing the application with 5 through 8A to show an unreasonable adverse effect. So they make different changes in theirs to 8 than you do. So on theirs, the opposing party has the burden for 5, 6, and 7, so traffic, municipal, educational, and then 8A, because they took away just 8. So 8A is aesthetics, which is also in yours. So the only difference in theirs, I think, is that they also moved rare and irreplaceable areas when they rearranged A, and so in theirs, the burden is on the applicant with respect to rare and irreplaceable, and yours, it's on the opposing party.
Yeah, we heard.
I don't know if we have
I thought ours
discussed
was,
rare.
ours was gonna, I thought for wildlife anyway, it was gonna be, oh, I see, but for
They
rare and
agree, theirs
irreplaceable.
agrees with
Yeah,
that.
okay, but not for a rare and irreplaceable.
Yeah. So theirs is close to yours, but not exact.
Questions on this? Representative McCullough.
We bifurcated the first condition, and made it two conditions. Is that correct in my memory? And so on our side where it says 1 and 2, does 1 and 2 on the joint proposal mean the same thing as ours, or did they use the old?
It's the same. It's essentially the same because yours is air and then water, and theirs is still air and water, and so they're still the same.
Yes, ours is air 1, water 2.
Yep.
Theirs is air
Air.
and water.
Yeah.
So what's their number 2?
So criterion, it's criterion 2 is existing water supply, and so we merged 2 into 3. I know it's.
Or we merged the water in 1 into 2. We made 1 just air. So we wouldn't have this air-water problem for the next 50 years.
Right.
Yes, but currently status quo, criterion 2 and 3 are also about water, and we in your draft merged them because they're similar. So the current criterion 2 is sufficient water available.
Yep.
And then 3 is burden on existing water supply, and so your draft makes those 2 things one,
Right.
and theirs doesn't. So all of those things still exist in the same place in both.
Okay. Thank you. Not to worry. Yeah.
But right, and so theirs doesn't include under criterion 1 the air contaminants and greenhouse gas emissions.
Thank you.
Right, and then your next.
So this is the list of things not addressed in the joint proposal that exist in your draft 9.2. And it's not a chart, it's just a list.
That makes Ellen happy.
I mean, I don't want to have there to be so many charts that it's confusing about which chart I'm referring. So this is
Right here.
so this is the list of things. So as we were just talking about, the first thing, they don't address sort of the reorganization of 1, 2, and 3 with air and water. They also don't address air contaminants and greenhouse gas emissions that are in your new sub-criteria. They don't have anything in about the definition of commercial purpose. They don't have anything about the development cabinet or the increase in the per diem rate. They don't have anything about slate quarries and pre-existing pits and quarries. They don't have anything about releasing property from Act 250 jurisdiction, except for the properties that are in the designated downtowns.
Right.
But yours is more broad than that. And they also don't have anything about environmental justice and racial equity directly. Perhaps arguably, but there isn't any direct new sections related to that.
questions about this?
Are the omissions just because it didn't fit with what they wanted to do, or are the omissions just because they felt the situation was settled and can move on?
I love when I've anticipated the question. I sent this list to Peter Walk, and he was gonna answer that question for us. I don't know if anyone from the administration has that response yet.
Hi, Billy Coster, NR. You know, Peter did send this around late yesterday. I think it's a mix. Some of these, there was a reason behind, others may have just been oversight, so we can respond in a definitive way.
Great.
You know, early next week.
Oh, I have another question too. The per diem rate, has that gone unchanged since
50 years.
$50 50 years? It's not tied to inflation?
I don't know that. It's been 50 for a long time. I don't know how long.
I don't think it hasn't been 50 years. I have it somewhere. I think it might have been changed in the 80s.
From 0 to 50.
No, from 25 to 50. It went up. I think it has only gone up once.
Based on a minimum wage vote today, what should we
Yeah.
drop the wages? Representative McCullough.
So, this isn't a question about the chart, but I guess a procedure of how we use the chart. And for my part, when we actually get to what I would call markup, early markup, we would be working from our version last April, and I would want to be working in the things that the committee wants to add from the joint proposal that they find good value in, and working them in the appropriate spots. So I would say you would have to help us put them in as we go.
No.
And further, now specifically about this, where these things, we want to make sure we recognize again in the appropriate spot in the books. That's just a thought.
I didn't hear all of it. You're concerned about losing track of these? We're starting, if we start with our bill, they'll be in it. Is that?
Well, our these are already in April.
Yeah.
Right, so I would just say
So-
you have an existing bill.
Yes.
So no, you can proceed with draft 9.2 as the committee sees fit.
Yeah.
You have received a proposal. It does not line up exactly with yours.
Right.
And so, you know, the next thing I would do would be to create you a draft 10.1.
Yeah.
And it will contain what you want it to contain.
So
And
as we
yes.
do a walkthrough or of 9.2, there'll be places where something should go, but it doesn't fit from the joint proposal spatially, and we'll have to put it in to a certain spot. Yeah, and so.
I will help you do that,
yeah,
yes.
Yeah, and you
You
don't
can
need
do
to help
that.
me do this, because it's just pointed out, we already got it in that one. It is Friday after.
It is Friday
Thank
afternoon, it's been a long week. Okay, thoughts on next steps or comments on the testimony we've taken this week in terms of, we spent a lot of time talking about board structure and district commissions, and I'd just love to hear thoughts from committee members on where you're at right now in terms of proposed changes in the joint proposal versus our proposal, or what's happening today.
I would, going off of Jim's comments, you know, it'd be nice to do a walk through the language, starting with draft 9.2, and as we go through, if you know, it could just be highlighted that, you know, this was another option essentially. We have this here, but the joint proposal has a different opinion, and then we compare the two and mix them. So I think we got, you know, I just having words in front of me is going to be more helpful, I think, than anything else at this point.
Yeah, I think it'll be a lot easier once we get that 9.2 and you start going through it, and she'll help us add the new stuff in.
Right.
It'll be a lot easier to comprehend what's happening.
Ellen?
Can I make a counter suggestion? So we have, this chart was a sort of a walkthrough of their language next to yours. If you are interested in taking any of their proposals to substitute for yours, I think many of them, the language needs work from a drafting standpoint. And I haven't drafted their proposal. So I don't know if that would help if I walked through all 84 pages of 9.2 and told you where things fit in. I would then need to draft a lot more. So if you are interested in pursuing some of their specific policy proposals and would like me to draft specific language,
I think that's where we would make the
Yeah.
decision, is what I'm hearing.
okay.
So we would walk through our bill basically, and then get to the places where there's, the goals are the same, but the words may be different.
Right.
And
Okay.
decide if we wanted to insert their words where ours are.
Okay.
And try to understand the merits of those, you know, differences. And then if we say, yes, and then I would expect that you wouldn't be left necessarily alone on that task, because it's coming from other people. At some point, you'll have to draft it from, yeah. Representative Bodie.
I feel as though if we start with our draft, and unless there's some compelling reason to take on looking at different wording, we just stick with our draft. Because we don't have that much time, and our draft is out of the commission recommendation, so I feel that's where I am.
Just to start.
Yeah, just if it's right, if there's no big difference, and they're recommending about the same thing, we stick with our wording.
That may come up,
Yeah, well, I think that I would like to resolve the issue of the boards. I think that's the most profound issue that we are now confronted with. And I think once we decide what we're doing with retaining or not the district commission, then we could go forward, or whether we're gonna replace it with what's being proposed by the administration of the NRC. I think once we make that deliberation and that decision, then the bill will fall. Then we can go from there, because I think there's a lot of recommendations here that it's just gonna affect who's in charge.
Representative Dolan.
I guess a fundamental question I have is in regards to just process. What we heard today is some of the recommendations regarding the change in the board under the joint bill had been estimated to reflect, you know, we had heard somewhere in the order of 4 FTE plus or minus, that would be equivalent to a $500,000 increase. And I guess if that's the case, if we end up with a bill that has a fiscal implication, does that mean that the board would need to look at its fees to be able to afford that increase in their budget? Or would that, if we were to incorporate any of that, would it need to then go to appropriations and Ways and Means to have them wrestle
Yes.
with the question of how they're going to stay, you know, afford that kind of change?
Yes.
So the yes meaning that they would, whatever kind of fiscal impact would need to go to the right.
Right, if we make a recommendation that changes the fees or the appropriations, we would have to, it would go to them to help figure that out.
Thank you.
Is it too early to say, I'm not in favor of that proposal?
It's not too early to say that.
I'm not in favor of that proposal.
Which proposal,
The
James Wire?
proposal from VNRC and the administration and the new idea for the court.
Do you wanna say why?
Why? Well, I was persuaded by testimony that, that what we have now is okay. I'm persuaded by what citizens said. I'm persuaded by what Liam Murphy, an attorney who works with developers and citizens has said. I can't imagine, I'm not thrilled with the idea of people going through 10 years of newly figuring out how things will work, and more court cases and more precedent, more everything else. If you want consistency, we've got something going now. I've heard that what we had before this system that's now in place was something that people really liked. And it got changed kind of as a compromise at the last minute. So, I wish we could go back to that. I would say hold with where we are unless we're gonna do something more like that. I'm open to hearing what people wanna talk about in our committee bill some more if you want to do that, but I'm ready to put aside for sure the VNRC proposal and to focus either on our committee bill or to say, that's it for today, for now.
Just to correct the record, it's a joint proposal, not just.
The joint, yeah, I meant joint. I was looking down, I don't know why I didn't say. Thank you.
Representative McCullough.
I guess what I interpret what I heard is, we'll take that joint proposal and push it all away, and just go with our 9.2 and work off of that. I believe that there's a lot of value in certain parts of that.
I meant the court part.
Well,
Sorry if I said the
okay.
wrong thing. I was talking about the court piece.
The court part and
The court piece is what I meant, that I say, put that to the side.
the court piece and the district commissions?
And the
'Cause
district
that's
commissions, yes.
integral.
That to the side, not deal with that. Then, but for the rest of the proposal, to really start with where we are.
Yeah.
That's ours, and unless there's a compelling reason to deviate from where we started with our committee bill, to stick with our committee bill. And if there's something that looks similar and we just wanna make sure that, that we consider anything special that looks like an excellent thing to add, fine. But we really start with our committee bill.
Well, I think that would fit with what I was gonna propose if you were shredding the entire document. Because there is good material in it.
Yeah.
But I would agree with you about the district commissions and then the resultant loss of them and what that means in the adjudication part. And I agree with Paul, he didn't use the word keystone, but whether or not to accept the joint proposal for getting rid of the district commissions and the resultant change in the new enhanced resource board is keystone to what we're doing. And then after we make that decision, then I think what I heard was other things will really start to fall in place for us. And while I like to start with easy things, like the definition on page 1 of perhaps, and I haven't looked at that for a while, that might not even be easy, but that is keystone, and I think I would agree with Paul that I do have a friend who said eat the biggest toad first. And that's what this is. And that's what this is.
Afternoon.
Yes.
Representative Bellman.
That's a hard quote to follow. Yeah, I think it makes sense for us to, at this point, start looking through our bill. I have to also acknowledge that we've heard from some tremendous witnesses, and I think I also want to take note of the incredible talent of the Natural Resources Board and the district commissions and their work. What we have heard is how professional they are, their the integrity of their work, and the involvement of the communities and concerned citizens is all a strength to our current model. And I would throw in a quote, not to break something that isn't broken, or what we heard yesterday about the value of good as opposed to perfection. So with that, I look forward to discussion on our next bill.
I don't know what our schedule is for next week at this point. I haven't looked at it. But sort of following on what people are saying right now, maybe first order of business for committee discussion, I said next week, not now.
We're starting the walkthrough right now.
Because I think it might take a while, is to work through this whole issue about district. I mean, some of us have been having conversations about where we are. I know personally, I've moved from a number of different positions and back to another position, and I have some thoughts about that, so maybe that should be our first order of business next week. I'm not, again, not seeing the schedule, and then do the side by side and move forward. It's similar to what you were.
You're suggesting that I have a discussion on the district commission or not, and then have a vote on it? It makes sure that we know what we're, so we can say yes or no.
We can take a.
Is that what you're suggesting?
Yeah, so I would like to resolve it one way or the other, and I don't mind if we have a discussion next week, but I just think that's what we should do initially.
Yeah, probably because not everybody's here.
Yeah, we've got people who aren't hearing the arguments.
Discussion.
Not yet.
Not yet.
Lee, do you have any thoughts on where you're at?
No, I'm just taking it in and leaving the. I wasn't even said.
Okay. Great. Thank you all for a fabulously busy week and being so productive. We're adjourned.
Rifleman's on 3 and 2 says
Did it work out for you?
very deep thoughts.